Happy anniversary, Daddy.
Thank you, son.
We're gonna go out today.
Yeah.
To the convergence zone. Right, Daddy?
Yeah, los chuecos y los cagaditos.
Yep. And both of them will be present at the same place at the same night. In the same
son.
car.
I love you.
Right, Daddy?
Yes, son. Damn, Joe.
What?
Next month I'm gonna be cagadito. Officially cagaditos.
Officially? Why do you say officially?
70 years, Joe.
Yeah, but you shit yourself a few times like 5 years ago.
I know.
And then your memory's just gone to complete shit. So bad that you're sending me to cartel territory.
So bad that now I am beginning to understand. The son of a bitch.
Don't go on Providence Road.
No, I'm trying to
Typically,
get...
it seems that we are going right to the arguments. Apparently, the arguments have commenced sooner than we expected, so we are going to go right to the Supreme Court.
Presidential immunity from criminal prosecution. There can be no presidency as we know it. For 234 years of American history, no president was ever prosecuted for his official acts. The framers of our Constitution viewed an energetic executive as essential to securing liberty. If a president can be charged, put on trial, and imprisoned for his most controversial decisions as soon as he leaves office, that looming threat will distort the president's decision-making precisely when bold and fearless action is most needed. Every current president will face de facto blackmail and extortion by his political rivals while he is still in office.
You're listening to John Sauer. He is an attorney for former President Donald Trump.
Here extend far beyond the facts of this case. Could President George W. Bush have been sent to prison for obstructing an official proceeding or allegedly lying to Congress to induce war in Iraq? Could President Obama be charged with murder for killing U.S. citizens abroad by drone strike? Could President Biden someday be charged with unlawfully inducing immigrants to enter the country illegally for his border policies? The answer to all these questions is no. Prosecuting the president for his official acts is an innovation with no foothold in history or tradition and incompatible with our constitutional structure. The original meaning of the executive vesting clause, the framers' understanding and intent, an unbroken historical tradition spanning 200 years, and policy considerations rooted in the separation of powers all counsel against it. I welcome the court's questions.
Mr. Sauer, to your last point, could you be more precise as to the source of this immunity?
The source of the immunity is principally rooted in the executive vesting clause of Article 2, Section 1. The source of it, Justice Thomas, I think is, as you described in your separate opinion in Civitofsky, for example, that the executive vesting clause does not include only executive powers laid out explicitly therein, but encompasses all the powers that were originally understood to be included therein. And Marbury against Madison itself provides strong evidence this kind of immunity, a broad principle of immunity that protects the president's official acts from scrutiny, direct sitting in judgment, so to speak, of the Article 3 courts. That matches the original understanding of the executive.
So how exactly would we determine what an official act is?
I point the court to two cases for that. Obviously, Fitzgerald against Nixon is the best guidance that the court gives, where the court adopted the outer perimeter test. And this court engaged in analysis there that's very instructive here, where it looked at the level of specificity at which the acts are described. In that case, a civil case, here it would be the indictment.
Well, what if you have, let's say, the official act is appointing ambassadors, and the president appoints a particular individual to a country, but it's in exchange for a bribe. Somebody says, I'll give you $1 million if I'm made the ambassador to whatever. How do you analyze that?
That, I think, would fall under this court's discussion in Brewster, where the court held with respect to legislative acts that bribery is not an official act, which also matches the common law background. So the way that this court in Brewster kind of sliced at the joint was to say accepting the bribe and the agreement to sex the bribe are not official acts. That's private conduct.
Okay,
subsequent appointment would be essentially an unrestrictable power of this court that Congress couldn't directly regulate.
It's not, accepting the bribe isn't an official act, but appointing an ambassador is certainly within the official responsibilities of the president. So how does your official acts or the official acts boundary come into play when it's going to be official, assuming that the president is innocent? But the whole question is whether he's going to be found innocent or guilty.
Again, I think Brewster and Johnson do address that, or very persuasively, at least in a slightly different context. Brewster and Johnson say the indictment has to be expunged of all the immune official acts. So there has to be determination what's official, what's not official.
Well, you expunge the official, you say, okay, we're prosecuting you because you accepted $1 million. They're supposed to not say what it's for, because the what's for part is within the president's official duties?
There has to be, we would say, independent source of evidence for that. And keep in mind that this indictment charges what this court has described as unrestrictable powers of the president. So the logical premise of this indictment is that Congress, by passing vague and general criminal statutes, has purported to directly regulate the president's exercise of things like the exercise of the appointment and removal power, things like his ability to speak directly to the American public, core exercises of his authority under the Recommendations Clause to recommend to Congress, members of Congress, the measures he thinks necessary and expedient. So you have an indictment in this case that goes right to the heartland of the president's powers, that alleges a whole series of official acts and tries to tie them together by saying, well, there's a private aim or a private purpose in that case, and that's a situation which, of course, could be alleged in virtually any indictment.
Counsel, it can be alleged, but it has to be proven. Malum in se is a concept long viewed as appropriate in law, that there's some things that are so fundamentally evil that they have to be protected against. Now, I think, and your answer below, I'm going to give you a chance to say if you stay by it. If the president decides that his rival is a corrupt person and he orders the military or orders someone to assassinate him, is that within his official acts that for which he can get immunity?
It would depend on the hypothetical, but we can see that could well be an official act.
They could, and why? Because he's doing it for personal reasons. He's not doing it like President Obama is alleged to have done it, to protect the country from a terrorist. He's doing it for personal gain. And isn't that the nature of the allegations here? That he's not doing these acts in furtherance of an official responsibility. He's doing it for personal gain.
I agree with that characterization of the indictment, and that confirms immunity, because the characterization is that there's a series of official acts that were done for an
No, because immunity says even if you did it for personal gain, we won't hold you responsible. How could that be?
That's an extremely strong doctrine in this court's case law in cases like Fitzgerald.
Well, we go back to Justice Thomas's question, which was, where does that come from? There are amici here who tell us that the founders actually talked about whether to grant immunity to the president. And in fact, they had state constitutions that granted some criminal immunity to governors. And yet, they didn't take it up. Instead, they passed an impeachment clause that basically says you can't remove the president from office except by a trial in the Senate, but you can impeach him after. So, or you can impose criminal liability. We would be creating a situation in which we would be saying this is what you're asking us to say, which is that a president is entitled not to make a mistake, but more than that, a president is entitled for total personal gain to use the trappings of his office. That's what you're trying to get us to hold, without facing criminal liability.
Your Honor, I would say three things in response to that. First, the doctrine that immunity does not turn on the allegedly improper motivation or purpose is something that this court has reaffirmed in at least 9 or 10
That's
cases.
absolute immunity, but qualified immunity does say that whatever act you take has to be within what a reasonable person would do. I'm having a hard time thinking that creating false documents, that submitting false documents, that ordering the assassination of a rival, that accepting a bribe, and countless other laws that could be broken for personal gain, that anyone would say that it would be reasonable for a president or any public official to do that.
Your Honor, as this court said very persuasively in Fitzgerald, that the allegation that this particular act would be done for an unlawful purpose or was unlawful could be made in every case. And therefore, if that were the doctrine, that the allegation of improper purpose is what deprives the objective acts of their immunity, then the immunity would have no purchase. And that's reflected in many of those cases.
Isn't the work, though, of the improper motive, at least in the absolute immunity context, to tell us what are official acts and what are not? I mean, I'd understood that even in the well, first of all, your ask is absolute immunity, isn't it? I
That's
mean,
our principal position.
That's your position is you want the same kind of doctrine that we've applied in other contexts when we say an official has absolute immunity. And my understanding is that when we say that, we mean for their official acts. Is that right?
Yes.
Okay, so any official act, so that then in that world, the real decision making from the court standpoint is whether or not something is an official act or not, correct?
That is an important determination by all means.
I mean, that's the determination in the absolute immunity world, because if you determine that it's an official act, then
They changed the
principle is
driveway
that you get
entrance
immunity
over
for
here.
it, correct?
That is correct.
All right, so my question,
bit.
and I think the Chief Justice may have asked this at the beginning, is how do you determine what, or maybe Justice Thomas, how do you determine what is an official act? And when we're talking about the kinds of scenarios that Justice Sotomayor brought up, one could say that when the president is using the trappings of his office to achieve a personal gain, then he's actually not acting officially, even if the doctrine was absolute immunity. So what do you say about that?
Two things in response to that. First, to the last point, that allegation that this was really motivated by an improper private purpose could be made in every single case.
No, I understand that, but it would have to be made. I'm just trying to assess. Even if we had the doctrine of absolute immunity, that same allegation and the facts related to it would come in, because the person would be arguing that he was not acting in his official capacity. He wasn't doing something official. He was doing it personal, correct?
I agree. The objective, or I'm not sure I agree, but
Tell the lady what you want, Joey.
Hello.
Hello, how are you?
I'm good. How about you?
I'm good.
I will have you got spicy chicken biscuits?
Yes.
I will have a spicy chicken biscuit and hash browns and an orange juice.
And an orange juice?
Yes.
Would you like any sauce or condiments?
No, thank you.
And you said it's for Joey?
Yes. How'd you know?
Oh, I heard him say your name.
Oh. Daddy, you want anything?
No, I don't, son. I don't want to eat in the car.
I'll be 8:54.
Okay.
Have a good day, guys.
Thank you.
My pleasure. Take care.
You too. See, this is how they...
Constitution suggests that they can be prosecuted after impeachment. The Office of Legal Counsel has said forever that presidents are amenable to a threat of prosecution, and they have continued to do their jobs and do all the things that presidents do. So it seems to me that you are asking now for a change in what the law is related to immunity.
I would quote from what Benjamin Franklin said at the Constitutional Convention, which I think reflects best the founders' original understanding and intent here, which is at the Constitutional Convention, Benjamin Franklin said, "History provides one example only of a chief magistrate who was subject to public justice, criminal prosecution," and everybody cried out against that.
No, I understand, but since Benjamin Franklin, everybody has thought, including the presidents who've held the office, that they were taking this office subject to potential criminal prosecution, no?
I see the opposite. I see all the evidence going the other way. Marbury against Madison, Mississippi against Johnson discussed this broad immunity principle that naturally.
So what was up with the pardon? What was up with the pardon for President Nixon?
I think
If everybody thought that the president
Yeah.
couldn't be prosecuted, then what was that
Thank
about?
you.
It was under investigation for his private and public conduct at the time.
Oh, thank you. Have a wonderful day.
Since President Grant's carriage riding incident, everyone has understood that
That was quick
Counsel, on
and easy.
that score, there does seem to be some common ground between you and your colleague on the other side that no man's above the law and that the president can be prosecuted after he leaves office for his private conduct. Is that right?
We agree with that.
And then the question becomes, as we've been exploring today,
Mr. Trump's attorney, John Sauer.
conduct that may or may not.
Can you spare me a,
I'm sure we'll spend a lot of time exploring
you
that.
want me to open that
But
dude
the
for you?
DC
No, I got it.
Blazing game.
Can
Chief
you
Judge
spare me one?
there, of the control behind the panel, expressed some views about how
Hash
to
brown?
segregate private
Well, I'm gonna
conduct
eat my
with
biscuit
no man's
first
above
since it was on the top.
from official acts. Do you have any thoughts about the test that they came
But
up
when
with
I
there?
get to them, I will spare you a hash brown.
Especially if it's understood through the lens of Judge Katz's separate opinion, is a very persuasive test. It would be a great source
What's
for this
the best way to get there, Joe?
in drawing this
Huh?
line. And it
How do I
emphasizes
get
the
there?
breadth of that test. It talks about
How did you what?
How do I get there?
Hawthorne?
Connected to the president's
Okay.
official duties or official acts. And it also emphasizes that if it's a close case or it appears there's considerations on the other side, that also should be treated as immune. Those are the aspects of that we'd emphasize as potentially guiding the
And
court's
that left
discretion.
open, in that case, the possibility of further proceedings and trial.
Exactly right. And that would be a very natural course for this court to take in this place. The court can and should reverse the categorical holding of the D.C. Circuit that there's no such thing as official acts, especially when it comes to.
But you'd agree further proceedings would be required.
That is correct. There would have to be, and I would point the court to Anderson against Creighton, where the court said there'd be kind of two stages to these further proceedings. There's looking at the indictment itself, or in that case it was a complaint, but look at the charging document itself and see whether on the face of it this is alleging official acts, and if not, or can't be determined, then there'd be a factual proceeding, and all that under Mitchell against Forsyth and so forth would have to occur before any other proceedings in the district can be pursued.
Mr. Sauer, you began by explaining why you believe that immunity from criminal prosecution is essential for the proper functioning of the presidency. But my question is whether the very robust form of immunity that you're advocating is really necessary in order to achieve that result. So just to take one possible alternative, suppose the rule
That's Justice
were
Samuel Alito.
a former president cannot be prosecuted for official acts unless no plausible justification could be imagined for what the president did, taking into account history and legal precedent and the information that was provided to the president at the time when the act was taken. Would that be sufficient, or if it is insufficient, why would it be insufficient?
That might be a much better rule than what emerged in the lower courts here. We think it would be insufficient because, again, that long line of cases talking about using the president's motives and the intrusive consideration of the president's motives as transforming acts to official and unofficial would come into play. And of course, once you can make that allegation, all of a sudden you've opened the door. You no longer have a per se clear bright line rule. You have a determination in every single case.
Well, what if it were not? What if it did not involve any subjective element? It was purely objective. You would look objectively at the various relevant factors.
That sounds to me a lot like Blazing Game, and especially viewed in a lens of Judge Katz's separate opinion, and that may not be different than what we're proposing to the court today.
Well, Blazing Game had to do with the difference between official conduct and private conduct, right?
That's correct. I understood the court to be asking that.
No, this would apply. It's just a possibility. I don't know whether it's a good idea or a bad idea, or whether it can be derived from the structure of the Constitution or the vesting clause or any other source. But this would be applied in a purely objective, on purely objective grounds when the president invokes an official power in taking the action that is at issue.
Yes, I believe the reason I think of Blazing Game is because it talks about an objective, context-specific determination to winnow out what's official and what is purely private conduct. And again, with a strong degree of deference to it.
I'm sorry, if I understood Justice Alito, he's suggesting not that. He's suggesting whether, even if it is an official act, whether you still grant immunity if that act is not plausibly viewed as within the realm of law. He can correct me if I'm wrong.
That was the question.
That, I think, would be a superior rule than the categorical denial that emerged in the trial court here. I do think it would be.
I'm not quite sure why he used the word plausible, because that seems to negate, but might as well give absolute if you're saying plausible, because anybody could argue plausibility.
Have you guys
We don't even require plausible, we require
Have you gotten
reasonable
through that?
and qualified immunity, so.
I'm about to. I just finished my biscuit. That was tasty.
No, seriously, they're honorable officers, and they are bound by the Uniform Code of Military Justice not to obey unlawful orders. But no, I think one could say that it's plausible that is legal, that action is legal. I'm sure you thought of lots of hypotheticals where a president could say, I'm using an official power.
Hold on.
And yet the president uses it
let you
in
know
an
where I
absolutely
am.
outrageous manner.
Okay.
That, if we're an objective determination, may well be an interesting approach to take.
So apply it to the allegations here.
Here you
What
go.
is plausible about the president
There's two of them
assisting
for
in
you.
creating a fraudulent slate of electoral candidates? Assuming you accept the facts of the complaint on their face, is that plausible that would be within his right to do?
Absolutely, Your Honor. We have the historical precedent we cited in the lower courts of President Grant sending federal troops to Louisiana and Mississippi in 1876 to make sure that the Republican electors got certified in those two cases, which delivered the election to Rutherford B. Hayes. The notion that it's completely implausible, I think, just can't be supported based on the face of this indictment, or even
Knowing that the slate is fake. Knowing that the slate is fake, that they weren't actually elected, that they weren't certified by the state. He knows all those things.
The indictment itself alleges, I dispute that characterization. The indictment affixes the word label to the so-called fraudulent electors. It affixes the word fraudulent, but that's a complete mischaracterization. On the face of the indictment, it appears that there was no deceit about who had emerged from the relevant state convention.
Joe,
Yeah.
the go-rounds are better.
Higher level point, a fundamental point, which is that, as Justice Alito's question indicated, there's a whole series of structural checks other than criminal prosecution that are designed to deter these kind of, outlandish scenarios or extraordinarily obviously illegal things. And that's been viewed in this court's opinions going all the way back to at least Martin
Where
against
do you
Monk.
think the D.C. Circuit went wrong in how it determined what was official versus what's personal?
Well, I read the opinion below in this particular case as adopting a categorical view. It does not matter is the logic of their opinion, because there is no immunity for official acts, and therefore, that's the end of the story. I don't really think they went wrong in Blazing Game in the civil context when they engage in the same determination with respect to what's official and what isn't official. There, we agree with most of what that opinion says.
And for some official acts that are not within the Article 2 exclusive power, and so official acts but not within the Article 2 exclusive power, Even for those, I assume you would think that a clear statement has to be required, a clear statement in the statute covering the
That's
president.
Justice Brett Kavanaugh.
Official acts are going to be criminalized.
Absolutely. Obviously, the issue is, at the highest possible level when it comes to the unrestricted powers, like as in this indictment,
Well, I'm assuming the exclusive powers are walled off and can't be prosecuted before there's a lot of official powers that are not exclusive to the president under his Article 2 authority. But for those, I understood you to be saying at a minimum there would need to be a clear statement in the statute referencing the president so that the president's on notice and can conduct himself or herself accordingly.
that's absolutely correct, and that'd be consistent both with Franklin and Public Citizen and cases a long series of other clear statements.
Can I follow up on that? Because
Go ahead. Go ahead.
so you concede that private acts don't get immunity.
We do.
Okay. So in the special counsel's brief on pages 46 and 47, he urges us, even if we were to decide or assume that there was
We're hearing
some sort
Justice
of
Amy
immunity
Coney
for
Barrett.
official acts, that there were sufficient private acts in the indictment for the case to go back and the trial to begin immediately. And I want to know if you agree or disagree about the characterization of these acts as
You have
private.
a swig of that orange
Petitioner
juice
turned to a
left?
private attorney, was willing to knowingly false claims
sure, when I open it.
to spearhead his challenges to the election results. Private?
As alleged, we dispute the allegation, but
Of
that
course.
sounds private to me.
Sounds private. Petitioner conspired with another private attorney who caused the filing in court of a verification signed by petitioner that contained false allegations to support a challenge.
That
Private.
also sounds private.
3 private actors, 2 attorneys, including those mentioned above, and a political consultant
Shit.
helped implement a
I
plan
might need you to
submit
open
fraudulent
this
slates of
thing.
presidential electors to obstruct the certification proceeding, and petitioner and a co-conspirator attorney directed that effort.
Damn.
You read it quickly. I believe that's
Yeah.
private. I don't want to.
So those acts you would not dispute. Those were private, and you wouldn't raise a claim that they were official.
As characterized, we would say, Your Honor, if I may, that what we would say as official is things like meeting with the Department of Justice to deliberate about who's going to be the acting Attorney General of the United States.
Sure.
Communicating with the
Did you
American
get your
public,
swig?
Communicating with Congress about matters of enormous
Thank you.
concern.
Thank you.
Thank you, counsel. And what is the consequence in terms of going forward with your acknowledgement that those are private acts as opposed to official acts?
If you look at the indictment here, there's a bunch of acts that we think are just clearly official. There may be allegations that mostly relate to what the government has described here as private aim or private end, and the court should remand or address itself, but remand for a Brewster-like determination, which is what's official and what's private. The official stuff has to be expunged completely from the indictment before the case can go forward, and there has to be a determination, at least on remand, of what's official, a 2-stage determination of what's official and what's private.
Well, if you expunge the official part from the indictment, how do you, that's like a one-legged stool, right? Giving somebody money isn't bribery unless you get something in exchange. And if what you get in exchange is to become an ambassador to a particular country, that is official, the appointment that's within the president's prerogatives. The unofficial part is I'm going to get $1 million for it. So if you say you have to expunge the official part, how does that go forward?
This particular indictment, where we say virtually all the overt conduct is official, we don't believe it would be able to go forward. There could be a case where it would, but if you look at even the government's brief in this case divides up the indictment into things that, other than the electors' allegations, don't really they haven't disputed that they are official acts, but what they do is say, well, we tie it all together by characterizing it as done, and these are the allegations that the court just referred to, by an improper private aim.
You can throw this stuff in the trash.
Yes,